What's up, everybody? Welcome to the broadcast. So we're going to talk about the Fani Willis Nathan Wade saga when work meets romance. And apparently this is one that's gone bad. Now, I have been talking about this conversation. I've been having this conversation with you all for months now, since this prosecution first went underway. And as you guys know, it's turned into a hot mess. Those of you all in the chat room say hot mess. Those of you all who are just reading this on the rebroadcast, type hot mess in the chat room. My name is Dennis Sperl, and I'm Uncle D, also known as the Blizzard King. And from time to time, I like to comment on issues affecting, the Black community, but specifically Black men. But you know, when it comes to something, this is a softball. I mean, this is one we could hit out the park. I called it a long time ago. Nevertheless, unless you've been living under a proverbial rock, you already know that in Fulton County, a pivotal hearing unfolded concerning District Attorney Fani Willis and her alleged conflict of interest intertwined with her romantic involvement with Nathan Wade, sparking concerns over ethical breaches and potential legal ramifications. At the heart of the matter lies the timing and perceived impropriety surrounding Willis's hiring and financial favors bestowed upon Wade, who is her romantic partner. Somebody type Labu in the chat room. And this has raised eyebrows regarding the fairness and impartiality of the case Willis is prosecuting, particularly whether it truly qualifies as a racketeering case or if there are ulterior motives at play. During the hearing, Willis's performance as a witness came under harsh scrutiny, with suggestions that both she and Wade may have lied under oath regarding the timeline of their relationship. This discrepancy between their two testimonies and that of a witness adds weight to the possibility of perjury charges. Moreover, the financial transactions related to trips taken by Willis and Wade have further fueled suspicions of improper benefits and potential disqualifications of Willis from the case. If proven, this could necessitate that the case's reassignment happen quickly, it go to another jurisdiction, or to the State Attorney General's office. Now, the proceedings encapsulated a broader debate on the ethical quandaries confronting prosecutors and the repercussions of personal entanglements. Somebody type Jada in the chat room. Somebody type entanglements in the chat room on the legal proceedings. The thing is, disqualification is based on appearance of impropriety. And that highlights the importance of upholding the integrity of the legal system, okay? Now, we can speculate on the future trajectory of this case, and we can ponder whether it might be moved to a different jurisdiction or dismissed altogether in light of these ethical concerns. Now, the main points: a potential conflict of interest involving DA Fani Willis and her lover Nathan Wade. The relationship is being scrutinized because of timing of perceptions of impropriety, given that Wade was hired by Willis and received financial benefits approved by her. Now, concerns about the nature of the case being handled by Willis, with suggestions that it might not rightly be prosecuted as a racketeering case and that a new prosecutor's fresh perspective might lead to the dismissal of the charges. That's something else that needs to be weighed. Willis's performance as a witness, as they always say, lawyers make horrible witnesses, but her performance was an all-time favorite of mine, and it should be reviewed in law schools all across America. Nevertheless, it characterized an unfavorable, or should I say, it's been characterized as unfavorable by most experts, and suggestions that both she and Wade may have committed perjury regarding the timeline of their relationship are serious questions that need to be weighed. A witness's testimony, i.e. Willis's old friend, basically contradicts their time frame. And that raises the possibility of not just perjury charges, but loss of law licenses and possibly jail. The notion that financial transactions related to the trips taken by Willis and Wade could indicate improper financial benefits to the DA, which could lead to the total disqualification from the case and potentially result in reassignment to a different district attorney's office. Here's the thing. Even if it's proven that she gave the money back to Mr. Wade, there's still a benefit in being able to go somewhere with your lover. There's still a benefit in being able to pay your boyfriend, your romantic partner, your paramour, this exorbitant amount of money so that he's able to raise his lifestyle. So then now, guess what? He can keep up with you. Now you don't have to go to that trip to the vineyards of California by yourself. You don't have to go to the Bahamas by yourself. You can go with your man, or vice versa. You can go with your woman because you've paid her. So there's some benefit to that. So even if he did give the money back, the mere fact that he was given money and she made the call to do that is just not something that can be avoided. Now, let's get down to the nitty-gritty, okay? Under Georgia law, when a judge is considering the disqualification and removal of a district attorney or a lead attorney from a case due to conflict of interest or other ethical concerns, there are several key factors that are taken into account. And these factors derive from statutory provisions, case law, and professional conduct rules. And they include the following: personal interest in the situation where the DA or the attorney must not have a personal interest in the outcome of the case. That could affect their impartiality. And this includes financial, familial, or other personal stakes in the case as a result. In such an interest, if that's the case, then the interest exists and it may warrant disqualification. Now, you understand financial, but familial means you elected your son or nephew to be the district attorney, or you nominated your son to be the special prosecutor. That's nepotism, and we want to stay away from that. That's the appearance of impropriety. Another one is previous representation. If the DA or the attorney has previously represented a party involved in the current case, this could create a conflict of interest. This is especially relevant if the previous representation pertains to an offense, charge, or substantially related to the current matter. There's no indication that District Attorney Willis ever represented any of the Trump defendants or Donald Trump, so that's not the issue. What I do want to talk about is something called the appearance of impropriety. Even if no actual impropriety exists, the appearance thereof can be enough to justify disqualification. The legal profession emphasizes the importance of not only being ethical, but also appearing ethical to maintain public confidence in the judicial system. Look, lawyers have enough jokes to deal with. And since we're a self-policing, self-governing entity or profession, it's always best if there's not even the appearance of impropriety. In this situation, it looks like the DA, Ms. Willis, hooked up her boyfriend. And on top of that, it also looks like she gave him money knowing that she would eventually reap the benefit of that, if nothing more than be able to go on the trip with him, something that he may not otherwise be able to afford. Okay. Now, the other thing, the fair administration of justice. The participation of the DA or an attorney should not undermine the fair administration of justice. This broad criteria encompasses many factors that could lead to an unfair trial or proceeding, including bias, prejudice, or undue influence. Here it looks like Fani Willis is like a devout left-wing liberal Democrat, and it looks political, and I think the rest of the world agrees with that. Another one is right to counsel and right to choose one's attorney. The courts also consider the right of a party to be represented by counsel of their choice. However, this right is balanced against the need to ensure an ethical and impartial legal process. Disqualification of attorney may be warranted if their continued involvement poses a significant risk of conflict or prejudice to the judicial process despite parties' preferences. There was a time when we used to have these what we call mob lawyers, and these mob lawyers, man, they they would work magic in the courtroom. What Giuliani did in the initial RICO cases up in New York, they were able to disqualify those mob lawyers based on the fact that, even though you have a right to choose counsel, we're going to disqualify you just because we want to ensure an impartial legal process. It seems unfair, but basically, if they want to get you, they can get you. Now, there are some other issues, screening arrangements. In some cases, it may be possible to address a conflict of interest by implementing screening arrangements within the prosecutor's office to see if who represented who may have a conflict of interest. That's not the issue here. If the DA's office is disqualified, the DA must notify the appropriate authorities, the Attorney General or the Executive Director of Prosecuting Attorneys and Counsel in Attorneys Council of Georgia, and the substitute prosecutor, such as the District Attorney Pro Tem, may be appointed to handle the prosecution. And that may be what happened here. Now, here's the thing. In the matter concerning District Attorney Fani Willis and Nathan Wade, all right, when I look at the Georgia law and I consider the facts provided, it leads me to the conclusion that favors the disqualification of DA Wallace and the reassignment of the case to avoid any appearance of impropriety or conflict of interest. How do I get to that point? Well, when I look at the personal interest, right, and I look at the financial transactions, the relationship between Willis and Wade, coupled with financial transactions and benefits arising from this relationship, directly implicates a personal interest that could affect Willis's impartiality. The hiring of Wade and approval of financial benefits by Willis, that raises significant concerns under Georgia law regarding her personal interest in the outcome of the case. Of course, she wants her boyfriend to do well. Wouldn't she? Yeah. And then either way, this situation clearly warrants consideration for disqualification to preserve the integrity of the legal process. Everybody's looking. The Georgia taxpayers are looking, of course. You look at it and it stinks. It doesn't pass the smell test. Next up, the allegations that Willis and Wade may have lied under oath about the timeline of their relationship. Whew. If that's substantiated, not only does it suggest potential perjury, but it brings significant harm to the perceived ethical standing and impartiality required of the district attorney. She's prosecuting Trump's 19 co-defendants, or Trump and his co-defendants, for committing perjury. And now you're telling us you may have committed perjury in this same case in the ancillary matter. Well, under Georgia law, even the appearance, let me say that again, even the appearance. So even if it's not true, the mere appearance of impropriety is sufficient grounds for disqualification, as it undermines the public confidence in the judicial system. So even if she was telling the truth, the mere fact that a witness came up and said, yeah, they lied about their timeline or they have conflict of it, that's enough to disqualify. Okay? The other concerns raised about the nature of the case being prosecuted as a racketeering case, along with potential for perjury charges based on discrepancies in the testimony, directly impact the fair administration of justice. The involvement of Willis under these circumstances could bias the proceedings or give an undue advantage, thereby necessitating her disqualification. Another one, while screening arrangements might be considered to mitigate conflict of interest within a prosecutor's office, the extensive public scrutiny and the specific allegations against Willis herself suggests that mere internal screening may not suffice to address the ethical concerns. Therefore, notification to the appropriate authorities for the appointment of a substitute prosecutor as per Georgia law is appropriate recourse. They can't just erect a Chinese wall to keep her out of this. That's not enough. This case is ruined for that Fulton County. Okay, they've wasted a lot of money. They spent a lot of time on it, but there's no way it just looks dirty. here's the thing. Given the critical role of maintaining public confidence in the fairness and integrity of the legal system, and based on the outlined facts and the legal standards, I would advise Judge Scott McAfee, okay, who is a relatively young judge, to issue an order disqualifying DA Fani Willis from this case. Okay? This step is necessary not only to adhere to the ethical standards set forth by Georgia law, but also to ensure that the case is prosecuted without any undue influence or bias, to avoid any appearance of partisanship, especially considering the Judge McAfee's background and the high-profile nature of the case. It's prudent, because he was a former DA and he was a U.S. Attorney General in Georgia, okay? And he has a long reputation. He has a long career ahead of him. He's only 30. He's in his 30s. Somebody type, "The judge is for the judge" in the chat room, okay? Nevertheless, considering his own reputation, it would be prudent not to dismiss the charges outright, okay? But to refer the case to another district attorney's office. Why? He doesn't want to seem biased. He doesn't want to see, okay, you know what? She fumbled it. They fumbled it. We'll send it to another court and another attorney, or maybe send it to the Attorney General's office to see if they can have. Reassignment allows for a fresh examination of the case on the merits, including the appropriateness of prosecuting it as a racketeering case. Now, the new prosecuting team, after thorough review, they may very well conclude, and I think it's highly likely that they'll conclude that the case doesn't meet the criteria for a racketeering charge, right? Which was originally meant to put mobsters in jail, high-ranking mob bosses in jail. And this could, of course, potentially lead to a dismissal of the indictment. This approach ensures that the decision is made based on legal merits and ethical considerations without the influence of prior conflicts of interest, thereby upholding the principles of justice and integrity in the legal process, okay? Now, there's some other stuff I want to talk about. And I think this is just basic stuff, I think that, we should consider the fact, and I hate to even, because, think about it. In this instance, involving District Attorney Fani Willis and Nathan Wade, one lesson that's underscored is that it's a pivotal lesson about the complexities and the potential pitfalls of mixing business with pleasure. Somebody type "mixing business with pleasure" in the chat room. That's why they say they don't mix, right? Mixing business with pleasure, particularly with professional and legal realms. This situation entangled with allegations of conflict of interest, ethical breaches, potential legal ramification, illustrates several key takeaways. Number one, it highlights the importance of maintaining clear ethical boundaries between professional responsibilities and personal relationships. When these boundaries are blurred, it can lead to the perceptions of impropriety, conflict of interest, and questions regarding the fairness and integrity of legal proceedings. Okay? Professionals, especially those in positions of power and trust, must diligently uphold ethical standards to preserve public confidence in the institutions they serve. Transparency in professional dealings, especially when personal relationships could influence decision-making, is crucial. If Wade was messing up, if Wade wasn't qualified to do this job in the first place, she would probably have given him the benefit of the doubt, which seems like what she did. The man was a personal injury lawyer, he's never tried a RICO case. He might be a great guy, but he's just not qualified to deal with this kind of case, right? And had there been some sort of transparent procedure for handling such a relationship, including disclosures, which she didn't do, or recusal, if she had put somebody else in charge or being in charge of him, maybe the situation could have been mitigated, especially since the internal regulations that govern the DA's office say that she should have disclosed her personal romantic relationship with Wade, and she didn't. That she's infringing on her own laws. How can we expect someone to prosecute the laws when they don't even abide by their own laws that they're supposed to enforce. Okay. The other thing this case underscores the wisdom in keeping professional and personal spheres separate. While it's not uncommon for personal relationships to form within professional settings, clear guidelines and policies should be in place to manage these situations effectively, ensuring that personal affiliations don't interfere with professional duties and responsibilities. See, the reputational damage that arose or can arise from mixing business with pleasure, especially in high-profile cases, serves as a cautionary tale. It can erode trust in individual professionals and the broader institution they represent, potentially having long-lasting effects on one's careers and the perception of the professional field at large. This does not make lawyers look good. It doesn't make judges look good. It doesn't make anybody in the legal system look good. And that's why these rules are set up. This instance between Willis and Wade illustrates the need for ongoing legal ethical training for professionals in all fields. All right. Somebody needed to check her. Okay. All right. That who gonna check me, boo? Somebody needed to check her to save her. Because now what you see happening is a spiraling down. Now, you know, it's a reminder of how personal relationships can cloud judgment and influence decision-making. Professionals must be vigilant in assessing how their personal lives may impact their professional roles and the broader implications of their decisions on justice, fairness, and the rule of law. In summary, to be learned, or should I say, the lesson to be learned is maintaining a strict division between professional responsibilities and personal relationships. And it's essential. It's essential to uphold the integrity and transparency of fairness and professional practices. This is particularly vital in fields that demand high ethical standards and trust, such as the legal profession. Now, what do I think is going to happen? Well, it depends on if Trump gets elected. Again, in summary, I think the judge would be wise to disqualify Willis and Wade and the entire Fulton County District Attorney's Office, reassign it to another district attorney's office or the state attorney general, let them look at it. Now, what's going to happen to Willis and Wade after that? Well, they could get sued. They could get sued for malicious prosecution. If Trump gets back in office, he could assign the U.S. Attorney General's office to prosecute them for federal crimes, i.e. election interference. All this because what? So they lose their license, they go to jail, or at least they get prosecuted, all for what? Because they mix business with pleasure. This is something to think about, and it's a lesson for the ages. Nevertheless, we'll keep you posted on what's happening on this thing. Other than that, this is Uncle D. Make sure you like, share, subscribe. I'm out.
Diddle, 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 another sound get killed, duck a diddle, diddle, diddle. Sign on the will, duck a diddle, 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 another sound get killed, duck a diddle, diddle, diddle. Sign on the will, them one tie, them one tie. To come at them funeral and them no say, I know say.